Hello and welcome to our webinar on the topic of employment contracts and employee handbooks. And really, it's all about the why. Why do we have those documents in place within businesses, whether those are small businesses, medium-sized businesses, or even large ones? The date of this webinar is the 12th of July 2023. So all of the content is accurate as of today's date. Please just be mindful of the date that you're watching this webinar because employment law does change. I'm your presenter for today. My name's Emma Fay. I am the Managing Director of the HR Department Wilmslow. The HR Department is a national franchise. We support small and medium-sized businesses with all of their HR needs, whether that's recruitment through to managing performance, managing absence, managing people generally, legal compliance, such as the documents we're going to talk about today, employment law advice through to dismissals, redundancies, and that kind of thing. So if you do need any HR support, please do visit our website and you can have a look at the contact details for your relevant HR department office there. We all work locally in various parts of the country. So that being said, the webinar today, we're going to cover a few key things. Why have employment contracts in the first place? The latest law around employment contracts, why have a handbook, and some top tips for having good contracts and handbooks within your document. So hopefully some really useful advice for you to take away and go and review your documents if you need to, and potentially put new documents into place if you don't have those already. So let's start with employment contracts. The purpose of an employment contract is to cover the basic details of the employment relationship. Now, it's arguable that the employment contract is made up not just of that written document when you first employ someone and you issue them a piece of paper that has a lot of information on it. It's actually made up of the whole way you treat the person. So you can end up with an employment contract that becomes implied if you don't issue a written contract, or indeed if what actually happens in practice in your business is different to what you've put in writing. So an employment contract is there to cover the basics of the employment relationship from the very start so that both parties know what to expect, when to expect it, and those are mutual expectations as well. Employment contracts are a legal requirement to some extent. So the law actually specifies that employers must issue a written statement of employment particulars. And a written statement of employment particulars is defined in the Employment Rights Act 1996, updated, I think, as recent as 2020. And that will contain a number of things that are legally specified. So things like the employer's and the employee's name, job title, start date, how much the individual will get paid, hours and days of work, holiday entitlement, all the things you would really expect, but there is a prescribed list, and that's the important thing. A written statement of employment particulars is defined in the law, so do make sure that your contract is at the very least covering those minimum bits, and you can find that information online quite easily, and of course you can always contact an HR company such as ours for advice if you need to. The employment contract itself, though, goes a bit further than that written statement. So rather than simply including a list of basic information that is required by law, the contract is an opportunity to go a bit further than that and actually maybe include some expected behaviours, some expected processes. So booking holidays, for example, how to report sickness absence, any additional requirements, whether there's DBS checks, driving license checks, those kind of things. We're setting expectations, and that's what the document should really be seen to be doing. Yes, it is a legally required document, but actually the less we see it as a tick box exercise and the more we see it as a helpful document that welcomes an individual to our business, the better. And making sure it's actually relevant as well. So things like driving licenses will be very relevant for some roles. Home working, that will be very relevant for some roles. DBS checks, HCPC registrations, all of these things that won't be applicable to every business. You can even then go a bit further and set post-termination restrictions. So you may have come across restrictive covenants or non-compete clauses. post-termination confidentiality obligations, those kind of things that really help protect your business, but aren't necessarily legally required in a basic statement of employment particulars. The contract can be varied throughout the employment relationship. So the contract you issue when someone joins the business, ultimately things do change, particularly in small and medium-sized businesses. That could be varied through mutual agreement. So it might be that you agree a promotion, a pay rise, a change in hours, any of those kind of things. It could be that naturally your business changes. So if we think back to the coronavirus pandemic, we had a lot of contracts that were varied to enable home working. Previously, contracts might have said office as the normal place of work, and those had to then be varied. And actually, ensuring that your contract has in itself a variation clause, which allows you to vary the contract, can be very helpful, although it won't give you the right to just push through with huge changes without consulting with your employees. So employment contracts do ultimately change over the course of time, even things just like issuing pay rises. That is a changed contract. So you'll tend to find once someone's been with you a while, you'll have the original contract, but then you will have additional letters, emails that constitute changes to that contract as well. Legally required to be issued on or before the first day of employment. And this is important. This law was changed back in April 2020. We used to have an 8-week grace period. So we could wait 8 weeks and then issue the contract. Never a great idea, in my opinion, just because it can be awkward to issue a written contract when someone's already been with you for 8 weeks and then they don't really like the contents of that contract. So actually having that requirement to issue the contract at least on the first day of employment is a good thing, because it sets that clarity for both parties and avoids awkward conversations later down the line. So do ensure that your processes allow for that. So I've mentioned a bit about the law already. So the latest law is the Employment Rights Act 1996, which sounds quite a long time ago, doesn't it? But actually it was amended back in 2019 with changes that came into effect in April 2020, as I mentioned earlier. And given that this webinar is actually taking place 3 years after those changes came into effect, you would think it would seem strange to talk about them. But because of what was going on in April 2020, i.e. global pandemic, the changes did get a little bit lost, and we're still coming across businesses today who haven't updated their documents to comply with the latest law. And that's through no fault of their own. It was quite a busy time for most businesses. So let's just run through those changes now. These came into effect on the 6th of April 2020, but there was no obligation to reissue contracts for existing employees. So don't worry if you've got existing team members who are on an older style contract. However, if a staff member does ask you for an updated contract, you should issue one that incorporates all of these new changes. So some of these changes were to include details of working hours, so more detail of working hours, should I say, and whether those vary. A lot of businesses now, staff members' hours do fluctuate, whether that's with regards to shift patterns, whether that's in relation to business requirements, and therefore any such variation should be specified within the contract and how that might vary. Is there a rota, for example, and when will that rota be issued? How might that rota be changed, and how much notice will they get of those changes? All that kind of stuff should be in the contract. Mandatory training should also be in there, including training that is not paid for by the company. So if there is any training that you expect staff to do and pay for themselves, you must specify that within the contract so that they know in advance what they're signing up for, particularly if there's going to be cost implications and obligations to attend training. Make sure that's all specified within the contract. If there isn't any mandatory training within your business, you might want to just specify that as well, just to make it very clear that there is not any mandatory training, but you may expect employees to undertake training from time to time. The contract should now as well reference all paid leave. So previous to 2020, we generally talked about holiday, sick leave, We didn't generally go into any detail about any other types of leave, but there are a lot now. We've got all the family-friendly leaves. Think of maternity, paternity, adoption leave, shared parental leave, all these other types of paid leave. Now, you don't need to go into massive amounts of detail about every statutory right an employee has to paid leave, but you should make reference to them so that employees know that they may be eligible for these types of paid leave and that the company recognises employees' statutory rights. It may be that you have policies that actually enhance those rights. So you might have a maternity policy that offers more than the statutory pay, in which case you should, again, make that clear in the contract, and you can reference your external policies if you'd like to, or you could refer staff to other sources of information, such as the government website, for example. We should also mention in the contract any other benefits that aren't covered elsewhere. So in the contract, we'll be covering things like pay, holiday pay, and whatever, but there are now so many benefits that companies can offer and do offer to their staff, such as insurance related benefits, cycle to work schemes, all these other things, and we should be listing those in the contract as well. If any of those benefits are non-contractual, I know it can seem strange to say to include it in the contract, but you can specify within the contract that it's a discretionary benefit if that's the case, and if it's something that you may need to vary in the future. Some insurance benefits we will want to retain the right to change the provider, for example, and potentially even levels of cover. So just make sure you're being specific in there about those benefits. Otherwise, remember what I said about implied contractual terms. If it's not clear that it's that it's discretionary in the contract, chances are by offering it for a certain period of time, it'll become a contractual benefit. Finally, on the changes, details of probationary periods. So if you do have a probationary period for staff, you should specify how long that is, whether that's 3 months, 6 months, or something else, and what happens during that period. So this is the period where we will offer extra training. This is the period we will monitor your performance. At the end of the period, what will you do? Will you have a meeting to discuss? Will you send them a letter to confirm that they've passed? What happens if a letter or a meeting doesn't happen? Do they automatically pass probation, or does it extend? All those things should be in there so that it's very clear what that probationary period is all about. And again, if you don't operate probationary periods, I would think it's good practice to just actually make that clear in the contract and just say that there is no probationary period applicable to this contract, just so that it's very, very clear. So, written statements, another change that came into practice in April 2020. I mentioned that there was the big change that meant that these statements had to be issued on day one of employment at the latest, but there was also a change to say that they must now be issued to workers and not just employees. Workers, for those of you who aren't sure, are different to employees. It's not helpful that workers and employees is often used interchangeably, but legally they do mean two different things for employment law purposes anyway. A worker is generally a casual staff member, maybe a 0 hours worker, agency worker, that kind of thing. Previously, there was no entitlement for these people to receive a written statement at all, but there is now. So it'll be a different type of contract to the one that you issue to employees on the basis that workers are not employees. So you'll need to make sure that that meets the legal requirements, but doesn't give too much away. So workers are not entitled to the same level of employment rights as employees are. So do make sure that you're not accidentally issuing full employment contracts to workers, because you will end up in a confused mess potentially in the future. And again, if you do need some further advice on workers and employees and worker status in general, it is something that we do a lot of with our clients. So what if you don't issue a contract? I've already told you it's a legal requirement, but really, so what if you don't issue one? Well, first of all, the employment relationship is open to interpretation, and it may be unclear both for you as the employer, the employee, and ultimately, if you end up in legal difficulties with your employee for any reason, it's open to interpretation by a judge in an employment tribunal. So that can be very difficult. It might not go in your favour, and therefore actually having the contract very clearly in writing is only going to help make sure that employment relationship is explicitly written down. It's not open to interpretation, and therefore there's no ambiguity. If you don't have a written contract in place, the statutory entitlements for employees will apply. And oftentimes with our clients, that's absolutely fine, because they will only offer statutory minimum entitlements like holiday pay at 5.6 weeks per year, like sick pay at statutory sick pay. But one area that can cause difficulty is notice periods. Statutory notice period from an employee is 1 week. So actually, if you haven't written a contract that asks for more notice, and you really do need more notice, and 1 week would leave you in a bit of a pickle, it's tough, because the statutory notice period will apply. Whereas in your own employment contract, you can specify that notice period for the different levels of role within your business and ensure that it meets your requirements. So if there is no written contract, we would find that there's a lot less flexibility for the business. So within a written contract, we would often recommend considering clauses such as the right to temporarily lay staff off in the event of a downturn in business, the right for the business to require employees to take holidays on certain dates. That could be over Christmas, it could be during quiet periods, it could even be during an employee's notice period. We would often look to include mobility clauses. So this is where the company reserves the right to change the employee's place of work to any other office which it may open in the future. And the variation clause, which I mentioned in brief before, which allows some variation of the contractual terms within reason by giving a month's notice. So if you don't have those things written in a contract that's agreed between you and the employee, you can't do them. You've got less flexibility as a business. So that's where the written contract can be really helpful. And in the worst case scenario, if you do end up in an employment tribunal situation, whether that's a claim for unfair dismissal, wrongful dismissal, it could be breach of contract, discrimination, any of those things, employment tribunals will look to award an additional 2 to 4 weeks pay to any employee who hasn't been issued with a written statement. It isn't a claim on its own, so an individual can't bring an employment claim solely on the basis of not having a written statement, but it certainly won't be looked upon favourably, and you could end up having to pay more in addition to the already costly tribunal process itself. So, our top tips for a good employment contract: please ensure it's tailored to your business. We've seen many contracts over the years. We have seen contracts that use the wrong company's name throughout. We've seen contracts that refer to the wrong type of business. So they're talking about a completely different industry, and you can tell by reading it. And just think about the additional clauses that are relevant to particular roles in your business. So those that are more senior, that are harder to recruit, you might want those longer notice periods. You might need stronger post-termination restrictions for those kind of roles. Making sure it's really tailored is important. You can get a lot of template contracts. Some of them are good as a starting point, but I would go that step further to make sure it actually suits your business. In terms of that as well, before I go on to the next point, even just making sure it reflects your language is really key, and making sure that you understand it yourself before you issue it to your staff member. We have, again, seen real problems arise within businesses where the contract hasn't really been read by the business owner. They've maybe borrowed it from another contact of theirs and thought, that'll do, we'll issue that. And we've gone through and done a review and said, oh, do you know that you're offering 3 months sick pay here? Do you know that you're offering 28 days holiday plus bank holidays, or did you mean 28 including? And it's because it hasn't been read and understood initially, and therefore it's been issued, it's created a contractual obligation, and that's a potential very costly mistake and a very difficult conversation to have with the staff member if you need to retract that. So do make sure that you understand it yourself, and if you don't understand it, there's a good chance that your staff won't either. So consider rewording it or seeking advice as to how you could reword it to make sure it's fit for purpose. Keep your master document up to date as the business evolves. Again, we often go in and review these documents for our clients, and we see that they've maybe not been updated in the last 10 years. Well, chances are the business has changed over that period, and the law has changed over that period. So make sure your master document is kept up to date. An annual review can be really helpful. Especially over the last few years, we've seen massive changes to our clients, including things like I've mentioned before, home working, the use of equipment away from the office and all that kind of stuff. So if you're then seeing contracts that say that you must not take IT equipment away from the premises, yet you've got all your staff home working, it kind of shows that that document is way out of date, and it becomes quite irrelevant. Keep any amendments in writing. So even if it's a positive change, such as a pay rise, a promotion, I would say it's always a good idea to make those amendments in writing. So it could be just an email to your employee to confirm the change and the date that becomes effective. Equally, any changes where you are making amendments to hours or to place of work or anything like that, please just keep them in writing. It keeps a really good paper trail and avoids any problems later down the line if there is a query about when a certain change took place or what is the true nature of the contract between the parties in the event of a dispute. I mentioned before about language, and I would just suggest avoiding that real overly formal or legal type language if that's not how you would normally communicate with your staff. I've even seen contracts in our clients' businesses where they are very legally written, and I struggled to understand what was being said in the contract. It certainly didn't reflect the way that the company would communicate to its team normally. So don't be afraid of just changing that language. And again, if you're not sure how to change the language without changing the context, excuse me, just get in touch with the HR company. They'll help you do that. And a good HR person should be able to write a contract in more plain English language without it taking away the legal impact of that document. And again, on language, if you do have employees who don't have English as the first language, you should get those documents translated so that they can understand easily and ask any questions rather than assuming that they're okay with an English written contract. So moving on then to employee handbooks. We've talked about contracts being a legal requirement. Well, employee handbooks are not a legal requirement, but there are certain policies that are a legal requirement, but they don't have to be within a handbook. So disciplinary and grievance procedure you should have, even if you've only got one employee. A health and safety policy, if you've got 5 staff or more, is a legal requirement. And you should have a data protection policy as well, and that's from the GDPR coming into effect in 2018. So even if you don't have a handbook and you just want to start with the basic policies, do make sure you've got at least those ones in place. And if then you're a growing business, maybe you've only recently started taking on staff, I think it's always good to consider just building policies around your team rather than starting with a massive suite of formal policies that no one will read and that don't reflect your culture, because you don't know what your culture is yet when you've only just started recruiting and things. So building the policies around the people and not the other way around, I think, is a nice approach to take. So 3 reasons why I would say it's good to have an employee handbook. And I'm talking here about employee handbooks as such a wide range of documents. We see that range from a document that's got maybe 10 to 20 pages and it cross-references to policies that are external. And the handbook itself is very much welcoming people to the business. I then have seen handbooks that are over 100 pages long and they're very detailed, and there is an expectation that staff read those. So handbooks can be exactly what you need them to be for your business. So keep that in mind. And I think handbooks are great for communicating the culture, values and mission of the organisation, which is particularly nice when you've got a new staff member. So in that period, maybe where someone's waiting to join, they might be in a notice period, or they might be undergoing screening checks before they join you, or maybe it's the first few weeks and they're in induction. giving them a handbook that actually talks about how the business started, who the key people are within the business, what's the vision for the future, what are the expected behaviours here, how do we do business. Really nice way to introduce people to the business and set those expectations from the start. Conflict resolution. So ultimately conflict does arise in businesses, and by setting out clear processes as to how we address conflict and how we resolve conflict within the business can be really helpful when those situations arise. By setting out some expected behaviours and conduct, so even setting out the unexpected, what we don't want our team members to do, really helps tie into those values and behaviours, but also makes it much easier to refer to if there is a situation of conflict that arises within the business. You can take a look at that relevant part of the handbook, refer the employee to it so that they are clear that this was an expectation set out from the start, and also refer to your policies within the handbook that help you resolve conflict. So there will likely be discipline and grievance procedures in there, but also maybe policies that talk about how to address conflict informally as well can be really helpful for staff and for managers alike. And my third one, there are lots more, but I wanted to keep to 3 reasons for the purposes of this presentation. A handbook can be a really good reference guide for both managers and team members. Day-to-day HR queries that arise, such as, I've just found out I'm pregnant, how do I know what I'm entitled to? Yes, of course, employees can Google those kind of things, but you might have a different policy. So actually, that query arises for a manager. So manager then thinks, well, I don't know, I've never come across maternity leave before. They can quickly look at the handbook and get the answer to that question, which can avoid you having to go externally for advice. Can answer most of those day-to-day questions about employment rights, as long as the document is kept up to date with the latest employment law. So it can be a really good, useful working document. So just a caveat then that these documents are only going to be helpful if they are relevant to your particular business, as I mentioned before. Templates that are pulled off the internet or sneakily stolen from another business might do a job, they might do the bare minimum, but they're probably not going to be as helpful as a document that's tailored and relevant to your particular business and industry. They won't be helpful if they're not up to date, because you're going to be referring to out-of-date information, and it kind of puts the credibility of the entire documents into question. And if they are easily understandable and accessible for all team members, they're more likely to be helpful than documents that no one actually wants to read, because it's full of legal jargon and it doesn't make any sense. Equally, if you've got a copy of a handbook that's sat on a shelf in an office and your workforce is generally remote, it's not accessible. So think about having an online version or an electronic version, and how you can make that easier for people to access. So just things like clickable links within the document can make a massive difference to how accessible that is. So that's our brief presentation about contracts and handbooks, which I hope has given you some food for thought about your own documents. We do offer a fully complimentary review of employment contracts and employee handbooks. So if you've just listened to this webinar and think, oh, we could probably do with a review, but we haven't got the time. Who has got the time when you're running a business, hey? Please feel free to get in touch with your local HR department office. We are all across the country. I myself cover HR department Wilmslow, which is Wilmslow in the centre, Alderley Edge up to Bredbury in Stockport and anywhere in between. So we are very happy to help clients in the local area with reviewing those documents. It's no obligation. We'll give you some tips and advice if we think your documents can be improved in any way. And that's it. All you have to do is send those documents over without anyone's names in, please. My contact details are on the screen. If you would like more tips and advice of a HR nature, you can follow us on social media. If you search at HR Debt Wilmslow, we are on Facebook, Twitter and Instagram, and then I am on LinkedIn as Emma Fay. Thank you very much, and if you've got any questions, please don't hesitate to get in touch. Have a great day.